All right, perfect. So this is really about uncomplicating the law. So a little bit about me. I'll keep this introduction brief. I've been practicing law for almost 2 decades now. Our firm works strictly with business and entertainment law clients. So our clients range anywhere from the startup entity to we have a couple of Fortune 500s that we work with on a contract basis. So our experience ranges through all different industries, all different sizes of businesses. I've actually myself personally owned, co-owned, or sold 10 different businesses over the past almost 20 years since I graduated law school. I'm also a husband, father of 3 amazing kids. One of them is 19 years old, which is kind of strange to me. And about me as a lawyer, I tend to take a very practical approach to the law. I'm a business owner myself. I don't overcomplicate things. I don't over lawyer things. I try and get right to the essence of the problem and solve it for my client. So that's what I want to really talk about, 3 areas of the law that every business owner needs to understand in this presentation. So write down questions, put them in the chat. Like they said, I'm happy to answer any that you have. I'll share my email with you at the end of this, so you can feel free to email me and answer any questions I didn't address in this or anything that you may just have on your mind. So when you think about the legal stuff, what I like to say is every aspect of your business intersects the law. And think about that from whether you sell coaching services online, you have a product you sell, you're a large financial services business, everything you do intersects with the law, from leasing space to your contracts with your customers or clients or employees. The website you put up, you got to make sure it complies with various aspects of privacy law. If you're taking payments via Stripe or PayPal, PCI compliance, there's a lot of different things your business intersects with when it comes to law, but you don't have to know everything, right? That's why there's experts like Julie and Corey and myself. We're here to help. And what I always tell people is 95 to 99% of the problems you'll have in a business can be avoided by anticipating them. That's what lawyers do. That's what we help people with. Now, the big question people have is, lawyers are expensive, or a lot of people think we are. I tell people, don't be penny wise and pound foolish. There are certain things you should absolutely pay someone like me to do, and there are other things that you absolutely should not pay me or someone like me to do. And that's what you got to understand when you're building your business, talking, kind of touching on something Julie talked about, the foundation. Well, part of that foundation is the legal structure, the legal issues you will face, and you need to know when you need to bring an expert on for that and when you don't. So take it one step at a time. Everything, you don't need to do it all at once. You kind of got to know where you need to start with that foundation and build from there. So the 3 areas that every business owner needs to understand is really your entity or company structure, contracts, and then the big dilemma that most people face when you start growing a business is the distinction between employees and independent contractors. And we'll touch on all of these, and I'll try and make it as efficient as possible as we go through this. So to start with, entity structures. So what are the common types of entities people have? You can be a sole proprietor, you can be an LLC, a corporation, or a partnership, either a general partnership or a limited partnership. And when I sit down with a new client and they come into me with a business idea, they always ask, what is the best entity to form? Or do I even need an entity? And the answer is, it really depends on each individual situation. Now, the 2 most common entities that you'll deal with or see in business is the LLC and the corporation. And I will tell you this, I've been practicing law, almost 2 decades. I've set up hundreds of businesses. I would probably say that 99% of them have been LLCs because, 1, they're cheaper to set up. They don't take a lot of company maintenance. And the whole reason about being a corporation, unless you're a large organization that wants to get investment at some point or go public, the only benefit of being a corporation is a tax election you can make. But with an LLC, you can actually make, it's called an S Corp election, and get the tax benefits of that. So that's, from my perspective, I think the LLC for most small to mid-sized businesses is the best entity. And the benefits of that, you get liability and asset protection. There is the tax savings when you can make that S corp election. And the other thing, which isn't necessarily legal, but it legitimizes your business. I have a lot of clients that are contractors, subcontractors. They work on houses, and when they deal with clients, most clients feel comfortable seeing that they are an LLC. If it's just, Joe Smith Contracting, as a sole proprietor, people get concerned. They feel that, oh, they have fly by the night type of business. So having that entity gives these businesses legitimacy. So really, another question again comes down to whether you need an entity. And I would say in most cases, if you are just starting out and maybe you're getting into consulting or coaching, you can operate as a sole proprietorship, really just to see if the business has legs. You don't necessarily have to spend the money to get an entity set up from the beginning. That's something I typically tell people. But once you see that you're getting clients, you're getting ready to sign some contracts, it makes sense to have some sort of entity. And like I said, I always lean towards the LLC. And now what happens if you don't have an entity, right? You don't have that liability protection. You don't have the asset protection. And there's really two types of liability, inside and outside liability. Inside liability is liability within your business. So when you have an entity, right? So if I have an LLC, which my law firm is an LLC, I am protected individually from inside liability, meaning if someone comes into my office, trips and falls, and sues the business, they can only get what's in the LLC. They can't get my personal assets. That's protecting me from that liability inside my business. Now, one misconception people have is an LLC doesn't protect you from outside liability. Like if I leave my office tonight, drive home, get in a car wreck, and someone sues me, just because I have an LLC doesn't mean any of my assets are protected, because the liability falls outside of my business. So that's something I always like to clear up with people when we're talking about setting up their structure. Is the entity itself protects you individually and all of your individual assets from inside liability. It doesn't protect you from outside liability. Now, another question I get is, where do I set up the entity? A lot of people hear Delaware Corporation. Do I do it in Wyoming, Nevada? My theory is, if it's an operating business and not an entity used for real estate, form it in the state where you're located. It makes things simple. I'm in Pittsburgh, Pennsylvania. If I formed an entity in Delaware, I have to file in Delaware. I have to pay for a registered agent in Delaware. Then I have to come back to Pennsylvania and file in Pennsylvania as a foreign LLC doing business in PA, because that's where I operate. Now, there can be some state income tax benefits, but throughout my career, I've found it's best, and the most simplest way to handle it is filing your entity in the state where you're actually operating from. Now, the next thing when it comes to entities, right? Should I do it myself? There's those DIY sites out there, the one that, rhymes with legal room. And here's what I will tell people. Those sites are good for certain things. Setting up your entity or your company, I would never recommend doing that. There isn't much of a price difference when you go through the whole process of those DIY sites compared to using a lawyer. The documents you get from those sites are wholly lacking. I mean, think about it this way, like Julie spoke about the foundation. This is the foundation of your business, your entity. That's something you want done right from the beginning. And I'll give you one horror story. I had a client come to me. It was a partnership. There was two people in an LLC. They used that legal room site to set up their LLC. That gave them a general operating agreement, which is the agreement between the members of an LLC, how the LLC operates. Well, one of the partners actually committed some level of fraud, but there was nothing within that agreement that addressed this situation, how to get rid of a member if they commit some sort of fraud or do something wrong. So that entity cost them about we'll say $350 to set up with that website. Our firm typically charges somewhere around, $700 to $1,000 all in for everything. That situation to resolve that partnership issue costs them over $20,000. So to save a few $100s in the beginning costs them over $20,000. So you have to be very skeptical. And I always tell people, and I like to say it like it is, if you're not ready to spend that few $100s up front, there's some other things you need to think about as to whether you're ready to actually start the business, because that is your foundation that the entire business you're building will sit upon. So you got to really consider getting someone, a good lawyer, to help you with that, setting it up the right way. Now, the other thing when it comes to entities, and this is the last point on entities, is you got to plan for divorce, right? This is more applicable when you have partners or two people or more in a business. You have to plan for divorce, especially in the beginning. That's when everything's going well. That's when everybody's excited about starting this business and making a ton of money and really helping clients and doing good things. Plan for divorce then. And you got to think about, what happens if there's disagreement? What happens if a partner, God forbid, passes or becomes disabled? What if one of the partners that's married gets divorced? What happens to their interest? These are all things that need to be thought about from the beginning and put into your company documents. And that kind of reflects back on the last point as to why you typically do not want to use one of those websites to set up your entity, especially if you're in a partnership. So this is really one of the biggest areas of law as a business owner you have to understand, right? Structuring your company the right way. And a lot of you may already have this done. So I may be, just talking about stuff you already know, but for those of you that don't, this is extremely important. Now, the next area is contracts, right? As a business owner, you're going to sign and get into more contracts than you can probably imagine. And there are so many things that you may not even realize are a contract when you're doing them. And what I always tell people, if you don't know what you're signing or you don't know what you should have in your agreements with your clients, it's a disaster waiting to happen. This is where you really need to educate yourself and understand some certain basic principles of contract law to make sure you're protecting yourself and your business. So some basics of contracts, and this could be really basic, but this is what they taught us in law school, so I'm going to pass it on to you. So a contract in and of itself contains really three things. It's an offer, acceptance, and consideration. Consideration is what you're exchanging, money or the services. They can be oral or written. It depends on state law. Some states don't recognize oral contracts. And again, they come in all shapes and sizes. If you go onto a website, you download a new app and Apple wants you to click accept to accept their terms, you've just formed a contract. You go on those websites, when you're signing up for something, you're downloading something free, you click accept, that's a contract. I always recommend don't do that blindly. At least read what you're clicking. Now, I know I don't always do that, and I'll be the first to admit that, but you got to know what you're signing. So you don't want to ever do anything blindly. Now, as a business owner, these are some of the common types of contracts you're going to probably come across. Your service agreements, your non-disclosure agreements, independent contractor and vendor agreements, terms of service, distribution agreements, insuring agreements, which are what is really within an insurance contract when you buy insurance for your business, and then your partnership / investor agreements or your company documents. These are the common ones you'll probably see. And if you have any questions about these, which you may, please put them in the chat, because I could spend hours just talking about each one of these individually, but these are really the common types you'll see. And now these are the key provisions in those types of contracts that they should all have. The first one is a limitation of liability. And what this basically does is limit the amount you will be liable for. So if I'm signing a services agreement I'm going to provide a service that's, going to generate $10,000 a year in revenue. Well, I don't want to sign a contract that has unlimited liability, because I'm only getting $10,000. But say I'm doing IT services and I go into a computer system of a company and cause some data breach. Well, that could run into the millions of dollars of damages. And if I don't have a limitation of liability clause within my contract, I'm on the hook for that. So I typically recommend for all of my clients to try and get that limitation of liability clause within the contract to limit it to the amount of fees they were paid for the service. Because if I'm only getting paid $10,000 to do some IT work, but I cause millions of dollars in damage, I don't want to be liable for that. So that's an important provision. You also want to make sure you have a very good description of your services. And that is what is included, and more importantly, what's not included. Because the way contract law works, if it's your contract and you draft it and send it to a client, and you say, this is all the stuff we're going to do, and they're making the assumption that you're going to do a few other things related to those services, and you don't necessarily exclude them, well, the law looks at it as they construe that contract against the person who drafted it. So if a reasonable person would say, yeah, that service is related to what you said you're going to do, and you don't exclude it, a court of law will make you responsible to perform that service. You also need to make sure you have indemnification, which is basically if someone sues you for something the other party did, they will be responsible for that. So if if I'm doing something for a client and then a third party sues me because I maybe performed a service for my client, but then they modified it further, which caused damage, client comes and sues me, or the third party sues me, that client will be responsible for it. That's really what indemnification is. It's basically the other party is covering the claims brought against you by a third party. You also want to make sure you have termination rights. Like, how do you get out of the contract? Not every contract works. So you want to make sure you have provisions that allow you to get out of it. Payment terms. You want to make sure those are very clear, concise, when you're getting paid, what you're getting paid, and what happens if you don't get paid. Then if you're doing anything where you're creating, either content for people, you're doing some sort of services that relates to intellectual property, you're creating something new, you want to have provisions in that contract. And if you're buying services from someone that is creating content for you, maybe you hire a content writer or a ghost writer or a copywriter for your blog on your website, you want to make sure you have a work for hire provision, which basically means everything they create, that intellectual property is yours. And then the last thing, and this doesn't apply to every contract, you want to look at non-compete and non-solicitation provisions. They're not enforceable in every state, but you can structure contracts in a way that can make those provisions enforceable in certain instances. Now, just some common pitfalls that I see, I probably see 5 to 7 different contracts a day for my clients. And these are some of the common pitfalls. There's a lack of detail. Like I talked about the services, right? You want to make sure that is extremely detailed, what you're doing and what you're not doing. Another big pitfall is one party never signs the agreement, right? Someone sends me a contract, I sign it, send it over. I never get a signed copy back, but we begin performing under the contract. Is the contract actually formed? And a court will say yes, but then if the parties do things differently, they could actually change the terms of the contract by what they're doing. So that's something that's, I encourage people, if you sign a contract, make sure you always get the signed copy back before you start doing anything, because you don't want to change the terms of the contract by your actions. Another pitfall, using forms from the internet. And again, I could tell you a ton of horror stories when it comes to this. People that download a non-disclosure form off the internet, but it lacks the language it needs, and someone steals all their ideas. So there are certain contracts that I would tell people, if you have certain forms or agreements you're going to use on a consistent basis within your business, pay to have them done the right way. If you do it once, then you can they're not something you have to redo every time. So make the investment in getting them done right so you're protected moving forward. And what we've done with clients in the past, people that have gotten forms off the internet, we've actually taken those forms and modified them for them. So it was a lot less expensive for them, for us to spend 30 minutes reviewing and revising an agreement they have. Just don't ever just take it off the internet and just use it blindly, and make sure you actually read the contracts you're sending out to your clients or you're signing with your clients, because that's probably the biggest pitfall. People assume one thing, but the contract will say another. But because they never read it or understood it, they kind of screw themselves. Now, moving from contracts to another area of law, and let me just check on the time to make sure we're good. Um, this may not be applicable to all of you. Some of you may be solopreneurs, you may be just starting your business, but eventually as you grow, you're probably going to need more resources. And the employee versus independent contractor, this is a debate or a question I get from all of my clients when it comes to starting to grow and whether we hire an employee or an independent contractor. And one thing I like to tell people is just because you call someone a contractor doesn't make them one. The law, the IRS, the Department of Labor, they don't care what you call the person. They care about the actual substance of the relationship. And the reason why I bring this up, this is an extremely hot button issue in the law right now. I've had clients and friends of mine that have, other types of law firms. They've had clients that are under audit right now because they treated a large group of employees as independent contractors, but the Department of Labor and the IRS said, no, 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 they're not contractors. They're employees. Therefore, you owe us all these back taxes, back employment taxes and penalties. And they're fighting it right now. And they believe they were contractors because they called them contractors. But when they actually did the investigation of the substance of the relationship, they found that they were employees. So this is something that you really have to understand. Even when you bring on that first person you bring on, you have to know whether they are an employee or an independent contractor. And some of the questions you have to ask to make this determination is, who controls them, right? Do they control when they come in, what they do, and they're just producing an end result for you? Or are you controlling them, telling them when they have to be somewhere or do something or how to do it? Who provides the tools? Do they use their own equipment or do you provide it? How are they compensated? What is the substance they're doing? Are they paid for time or for a result? And the example I like to give to try and simplify this is, if I have a room in my house, we'll say that I want painted, and I bring someone on board and I say, I want this room painted. I need it done by Friday. You buy the paint, you bring your tools. I don't care when you come, as long as it's done by Friday, I'm going to pay you $500 to do it. That's an independent contractor. I'm not controlling the work. I'm not controlling how they do it. I'm not providing them the tools to do it. I'm just paying them for the result. Take that same scenario and I say, okay, I'd like you to be here between 8 and 4. I already bought the paint. Here's some brushes. I want it done by Friday, and I'll pay you, $100 a day. I would argue that's an employee because I'm controlling when they work. I'm giving them the tools to work, and I'm compensating them in a way that's a little bit different. So these are some important distinctions you have to understand as a business owner when you're bringing on employees. And you got to know when to use one or the other. And, independent contractors are a great resource to use if they truly are, because you save on employment taxes. You can really get more work done at a lower cost. Employees tend to cost a little bit more just because of the employer tax, the workers' compensation insurance you have to have. But this is something that I tell my clients when they get to the point where they're ready to bring somebody on board, let's have a discussion. Let's understand that what they're doing falls into the right bucket and we're treating them the right way. So again, these are some of the risks when you use independent contractors, right? The first one is, are they actually a contractor? There are tax risks. If you treat someone as a contractor and say you would hire me as an independent contractor and you send me a 1099 at the end of the year, and I never pay taxes on that money, say I make $50,000 and you send me a 1099. Well, the IRS wants their money and they're going to get it from someone. So if I don't pay it, they're going to come back after you. So that's something you got to be aware of. Department of Labor risks, right? If you get audited by the Department of Labor and they find that these people were truly employees, you're going to have taxes and penalties due to them. There are also liability risks, right? If they are an employer independent contractor, and they get hurt on the job and you don't have workers' compensation and they sue you. There's a lot of different liability issues there. And then also intellectual property risks. When you bring on an employee and they sign employment agreements or non-disclosure agreements, confidentiality provisions, for certain you own all the intellectual property they're creating. With a contractor, that may not be the case unless you have a really airtight independent contractor agreement and they actually are an independent contractor. So that's some of the risks you got to really think about when it comes to this, dilemma between an employee and an independent contractor. Now, again, these are some things to consider. Whether you use an employee or a contractor, you got to make sure you have the right documentation in place. For a contractor, I tell all of my clients, you sign a non-disclosure agreement and you have a very solid independent contractor agreement in place. For employees, if you have employees, you may know this already, you need an I-9, a W-4, typically have some sort of employment agreement or offer letter. And then even with one employee, you should have some sort of handbook or policy manual that dictates some of the rules of the business that you want these employees to follow. The more things you have in writing, the more processes and policies you have in place as a business from the beginning, the more protected you are. You don't want to get into a situation where you hire one employee and you don't worry about it. Then you look back 6 months from now and you now have 6 employees working for you and you don't have a handbook or policy manual in place. Everybody's kind of been doing whatever they want when it comes to work rules. Then you got to go back and reverse engineer putting these policies in place, and it can create some liability issues. Then when it comes to insurance, you want to make sure if you have employees, you have workers' compensation insurance. Your states typically require that. And then if you're using contractors, you want to make sure that all of the insurance you have in place actually covers the work of independent contractors. Like me as a lawyer, I have to have malpractice insurance. If I would ever outsource work to an independent contractor, my policy would cover that so long as I notify my carrier that I'm using an independent contractor for this type of work. So it's just something to be aware of. And again, really it boils down to doing the right thing from the beginning, setting it up the right way, categorizing the people the right way. That's how you avoid massive headaches down the road. And lastly, just a few other things to think about, and then I guess we'll turn it over for questions. From a legal perspective and as a business owner, the other things you want to think about, and I'm not saying right now, but as you grow, is your trademarks. Do you want to protect your name or your logo or your slogan of your business? Copyrights, if you write a course or if you write a book, like that's protected by copyright and other intellectual property. You also want, and I think Julie and Corey said there's going to be an insurance person in the course. So you want to talk about the insurance needs you will have as a business. Like for me, malpractice insurance, general liability insurance for when people come in my office, those types of things. Tax planning, that's extremely important. You don't want to end up, come April 1st, your accountant or CPA says you owe $30,000 in tax and you have $3,000 in your business bank account. You should be doing your tax planning right now as we approach the end of the year to make sure you can maximize your tax position and limit your tax liability as much as possible. Then you also eventually, as you grow a business and become more successful, you want to talk about personal asset protection. Do you put your business interests into trust and different things like that? There's so many things that you will come across as a business owner. And I'm just really touching on the surface of all of this. And I always say, Rome's not built in a day, and you don't have to do it all or know it all. That's what you let professionals do. So I hope this was informative. I hope this gave you some stuff to think about, and I'll turn it back over to Corey and Julie, and I guess we'll go to questions.
Yeah. So thank you, Rocco. That was
of course
a lot of great information. And we've got 3 questions specifically for you. And again, to everybody out there, if you have any questions, go ahead and type them in that Q&A there, and we'll answer them as we can. So we're going to go ahead and just ask your questions, or ask the questions to you, Rocco. And if we have time, then we'll get to ours. Otherwise, Julie and I will answer those offline. Suzanne's the only one that asked one that was not related to your presentation. So this comes from Suzanne. In the line of business we're setting up, we allow potential customers to test our mowers to see if if this machine is the right one for their needs. If an injury would occur while testing, is this covered under the LLC, even though we're not testing on our site?
So great question. And so if it's part of your business and the mowers are owned by the LLC and that type of situation happens, then yeah, you would have that protection of the LLC pending you're doing everything else right. You're not commingling funds, you're following all the corporate formalities. One thing you may consider doing though is creating a one-page waiver that if anybody's testing the mowers, it's maybe a paragraph or two that they're signing that it's at their own risk. And if they get injured while testing the mower, you're not responsible for it. That's a great way to just limit your liability even further. The LLC will protect you personally, pending all the other things are in place. But creating a one or two paragraph waiver is a great way to just add some liability protection on top of that. Hope that answers your question.
Yeah, and also I think that that's going to be another. You might want to re-ask that question when we get to the insurance part as well, Suzanne.
Yeah, because insurance definitely will cover that as well if you have the right policy in place.
Yeah,
absolutely.
Exactly. Can you place various business branches under a singular LLC / S Corp umbrella, or is it best to have separate LLCs?
Okay, another great question. And what I typically recommend clients to do, if they are related businesses, we'll sometimes create a structure. We'll have an LLC at the top that makes the S Corp election. So you run all the profits or losses from the LLCs below up to the holding company LLC to get the benefit of the S Corporation. That's when the businesses are related. If they're unrelated businesses, I don't like to mix the liability, right? So if I have, if I'm doing rental properties over here and I have a consulting business over here, I don't tie them together with a holding company. I keep the real estate over here. I keep the consulting business over here. But like one of my clients, they're a cleaning company. So we actually going through this right now. We're restructuring their entities. They have one entity that does, housekeeping. We're actually creating a holding company. So the holding company is going to own this entity over here that does the housekeeping. We created another entity that actually hires all the employees and leases them to the housekeeping company. And then we're setting up a third entity that will do commercial cleaning. Because it's all related, we're rolling them all up into one. So it really depends on the businesses. If they're related or similar, then yeah, you can structure it that way and make the S Corp election at the top to get you that tax savings.
Okay. Next question, and I'm just going in order of how they came in for everybody out there. Non-competes aren't always enforceable in all states. How do you get around them?
Yeah, so what I always tell people is you kind of got to understand whether you're talking about a non-compete or a non-solicitation. So non-compete, and you're right, they're not always enforceable in every state. That just says I can't go work for your competitor. And what I tell clients is that really what you're trying to prevent, or are you trying to prevent them from taking your clients, your employees, or your intellectual property? Because that's a non-solicitation provision. That's what most clients are concerned about, the theft of the clients, the theft of employees. And what's good about the theft of the client piece, even if there's non-competes and non-solicitation provisions that aren't enforceable in a state, most states follow what's called the Uniform Trade Secrets Protection Act. Customer lists are deemed trade secrets. So if I have an employee leave and we don't have a non-solicitation, or in my state, they're not enforceable, a non-compete or a non-solicitation, but they start calling on my customers, I can sue them for theft of trade secrets. It's kind of a backdoor way to hold employees liability that leave your company and work for a competitor or work for, or take your clients. The other thing you can do, if they go to a competitor, what you can do is file a tortious interference claim against that company and make the argument that they knew they had a non-compete or an employment agreement. They induced this person to leave and it's causing you damages. It may not win in court, but it'll make their life miserable and give you some leverage to kind of either prevent that, get some type of agreement in place where they won't take clients or customers. That's another kind of backdoor way around it as well.
Okay, great. Next one comes from Josh. If you're going to have an international partnership with a company in the UK, what type of documentation will be needed?
Another good question. So that's one of those it depends answers. one, you need an agreement in place that deals with an international transaction, but it really depends on the type of partnership. If it's an entity partnership, then you have to structure it the right way and make sure the foreign investment is allowed in the US. If it's just a partnership for revenue sharing, then it's really just a simple contract in place that really outlines all the terms.
All right. This one's from Sean. So Mark Kohler and other national tax experts say that S corps should be formed when the consistent net income is 40 to 50K and the business owner is able to cut consistent, quote unquote, reasonable payroll. Do you agree with this approach?
100%. I typically tell my clients that you don't make the S corp election till you're profiting about $40,000 a year, because the accounting costs offset any tax savings, anything less than that. So once you start making, say you get to 50,000 a year, then you make the S corp election, because you can, in essence, pay yourself a reasonable salary of $20,000, and you pay, the ordinary income tax and the FICA, FUTA, Medicare. But on that other 30,000, you don't pay self-employment tax because you pay it as a profit distribution. So you save, I think it's 15.3% on that other 30 grand. That's a $4,500 tax savings. But most people don't make that election until you're at about $40,000, because the additional accounting costs, the payroll setup outweighs that cost savings until you get to that level. So I completely agree with that number.
All right. Next one from Cheryl. What if you are technically the product / service benefiting the company that is trying to enforce the non-disclosure? So this is a continuation of the.
So what if you are technically the product service benefiting the company that is trying to enforce? I'm not sure I understand the question.
That was a continuation from the non-competes and how to get them around them in the States, I'm guessing.
So, yeah. So, what's this say? So you were a morning. So that's going to depend on what your contract says with the company. How is that non-compete written? Is it overly broad? Is it very narrow? Because courts, if it is enforceable, courts want to see it very narrowly construed. They don't. I believe you're saying you're a morning co-host and you do voiceover work. So can you carve out voiceover work under that agreement? And you have to see how the contract is actually written to see if voiceover work would either be specifically listed or if it would be considered a service under the agreement. I hope that answers your question.
Yeah, maybe she needs more.
Yeah, you can feel free to email me, and you guys can pass along my email address, and I'm happy to jump on a phone call with you and talk through that with you if you'd like. I'm happy to do that.
Okay, yeah. She says, "Will do, thank you," because
okay,
nobody else on here doing voiceover work, so that's a little specific.
Yeah.
But no, appreciate that, Cheryl. And then Emily asked, "What type of agreement is necessary when brands agree to co-brand to grow their individual brands through marketing and education?"
So typically you want some sort of licensing or cross-licensing agreement, right? If you and this other company have a brand that you're going to, when you say co-brand, use to grow a bigger following or a bigger audience, you want to have some sort of licensing agreement where both of you are cross-licensing the use of the brand to one another, but either one of you own the actual intellectual property of the other. And then if you do create joint intellectual property, joint content, you within that agreement carve out who owns that or how you co-own it, what happens if there's revenue generated from that. So it's usually some sort of licensing agreement.
All right. I hope that answered Emily's question there as well.
Yeah.
All right. And then we have one last question from Suzanne, which I will field. And it's, wouldn't your strengths be tied to your value prop? And the answer is yes. So a lot of, or pretty much everything that we talked about, both Julie and I talked about, is going to be all about your foundation. So your strengths are going to be a part of your value prop. Your weaknesses can affect your value prop. Everything that we talked about is something that can benefit or threaten your foundation. So as a part of your secret sauce being a part of your strength, it can be tied to your value prop, it can be tied to your mission statement. That's all kind of preference, but it's it's all part of that foundation, that company culture. Julie, I don't know if you have anything else you want to add to that.
Nope.
All right. So that is seems to be all of our questions. So last call for questions. Otherwise, if you have any others, you can use the Slack channels that we have set up. So we've got that week 1 set up. If you have anything else that you want to ask any of us, and we can track down answers if we can't find them or if we don't know them. For everybody out there, expect an email later tonight. We're going to have a follow-up that'll just have a survey. If you wouldn't mind filling that out, we appreciate it. It's going to help us just make this better for everybody else in terms of, the content, how it's delivered, etc. So, if there's something you liked, you didn't like, we can change on the fly and make it better for week 2. We will have this video and all of the work that, the exercises and everything, we'll have all of that posted within 24 hours. So probably by tomorrow morning, but it might take a little bit longer depending upon whatever it is that we're going to deliver. But we have most everything ready for this week. So it should be pretty quick. You should see first thing in the morning. Beyond that, did I miss anything, Julie?
No.
Okay. Great. Well, appreciate everybody. Appreciate the questions and the engagement. Thanks again, Rocco.
Oh, it's my pleasure. I appreciate you guys having me.
Yeah. All right. Well, we will look forward to seeing y'all on Slack and talking to you next week. Thanks, everyone.